5 to 99 years or life in prison. I'm getting some attitude from you, and I don't understand that. If you want to wear a Michael Jordan jersey, Michael Jordan could afford to have attitude because he was exhibiting greatness. You are not. You're 25. When are you going to grow up and stop asking your mom to come down and cry and do this for you? Your mom should be enjoying the best days of her life, not dealing with someone who's 25 years old. You're a grown man and you're behaving like a child.
He was raised the correct way. He's a good kid. He really and truly is.
The moment this defendant entered the courtroom, his attitude set the tone. Confident to the point of arrogance, he showed no respect for the process, interrupting, posturing, and acting like he ran the place. But here's the reality. He's facing up to 99 years behind bars for serious drug distribution charges. With that much on the line, most would tread carefully. Instead, he challenged the court from the start, and Judge Boyd didn't hesitate to respond. This footage includes 2 separate hearings involving the same defendant. Viewers have had mixed opinions. Some prefer seeing the full progression, while others think each hearing should be viewed individually. Either way, both appearances reveal a lot about how this case is being handled. There's also growing public debate around Judge Boyd's approach especially when it comes to repeat offenders. Some critics argue she's too lenient, while others say she's giving people a fair shot at rehabilitation. As this case unfolds, it raises important questions about courtroom conduct, consequences, and judicial discretion. Let's take a closer.
All right, so what's being waived is count 1 only, correct?
That is correct.
Yes, ma'am.
All right, any objection to the waiver of count 1?
No objection.
All right, so what you're charged with in count 2 is possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment for a second-degree felony is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the state is able to prove the enhancement paragraph allegation, then your range of punishment will be anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, the state is proceeding on count 2. You'd agree that you've been previously convicted of 1 or more felonies. Punishment is to be assessed at 9 years in the prison. There's a $2,500 fine. There's no application for deferred adjudication. The state recommends community supervision. They're taking in consideration 2023 CR 4278, and there's to be restitution to SAPD for drug testing. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 6 years. There'll be a TAP evaluation and 220 hours community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged in count 2, how do you plead? Guilty, not guilty, or no contest? And to the enhancement paragraph, how do you plead? True or not true? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement paragraph true based upon your plea of true and based upon states exhibits 1 and attachments.
Thank
Are
you.
you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Are you employed?
Actually,
That's either yes or no.
No.
All right. How long have you been unemployed?
Actual 9 to 5.
Just 25 years old. This defendant is facing serious drug charge, as in what he shared in court only raised more eyebrows. When asked about his employment history, he admitted he's never held a traditional job. Instead, he mentioned doing side jobs, though he didn't offer much detail on what those actually involved. The courtroom reaction was telling. In a setting where credibility and accountability matter, Vague claims of side work without specifics don't go far, especially when the charges involve narcotics. And let's be honest, not all side jobs are created equal, particularly when they don't show up on a resume or a tax return. It's not about jumping to conclusions, but the optics aren't great. No formal work record paired with a drug-related case. It's easy to see why questions are being raised. People tend to connect the dots, and in this case, they're not forming a flattering picture. So what's the story here? Is this someone who got swept up in the wrong crowd, or are we looking at a full-time dealer trying to downplay his involvement? Let us know what you think in the comments. This one definitely sparks debate.
All right. If you are on probation in this court, I require a job, and I require a job where someone gives you a W-2. You understand?
Wow. So, moving company.
You need to provide proof of that. Do you have any children?
Yes.
How many?
2.
What are their ages?
4 and 1 on what?
Who do you live with?
I don't want my goodness.
If you're drug tested today, what are the results going to be? For everything, and that includes marijuana, alcohol, all of that.
I feel a little dirty.
Have you ever used anything other than marijuana? That's either yes or no. We're not doing notes. We're not doing all of this, and I don't understand. I'm getting some attitude from you, and I don't understand that. If you want to wear a Michael Jordan jersey, Michael Jordan could afford to have attitude because he was exhibiting greatness. You are not. So there's to be no attitude towards me in this court. Do you understand? And you will get a job. Do you understand? Am I speaking a foreign language to you? All right, then you need to answer my question. Do you understand that you will get a job? All right. So this is what we're going to do. You're going to step back. You'll wait. I'll take up sentencing later. And counsel, if you want to speak to your client about his attitude.
Yes, ma'am.
Thank you. This is what the court is going to do. The court is going to sentence you to 9 years in prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person. There's to be regular UAs, and he needs to be tested for levels. There's a $2,500 fine. That'll be probated. What are the court costs in this case, please? Take in consideration 2023 CR 4278. There's to be restitution to SAPD for drug testing. I'm going to want field visits 1 time per month until further notice. All right, the court costs in this case are $325. Will you be able to pay that in installments? Is there anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right.
Did you,
Yes.
Sorry, you said 9 years probated for 8?
Yes. All right. If he completes everything successfully, then he can always come back.
Yes, Judge.
All right. Thank you.
The judge once said he could always come back likely, not expecting it would happen so soon. 7 months later, the same defendant returned to court, this time with a new charge on his record. This wasn't a minor issue. He had violated release conditions and was reportedly found at a known drug house. Despite that, he appeared in court as if it were business as usual. In a previous hearing, the prosecution requested a 6-year sentence. Instead, the judge handed down an 8-year suspended sentence, an outcome that clearly surprised the defense. Looking at the full situation, the court had already given several chances. Even during proceedings, the defendant responded with defiance and had difficulty answering simple questions respectfully. At a certain point, repeated violations begin to show a pattern. The court's patience has limits, and accountability, eventually, takes precedence over leniency.
And are you Mr. Jones?
Yes, ma'am.
All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Kevin Alfred James Jones who was placed on community supervision in 2023, CR 5280, for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams, on January 22nd, 2024, for a term of 8 years? Is that you?
Yes.
All right, state.
Yes, Your Honor, violated condition number 1, on or about the 22nd day, May 2024, in Bear County, Texas, to Defendant Kevin Alfred James Jones, committed the offense of evading arrest or detention, in violation of condition number 1.
How do you plead to that? True or not true?
Your Honor, we'll waive the remaining violated conditions.
No
Any-
objection.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, sentence you to 9 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. All right. So why is he continuing to violate? Why is he violating probation?
Well, Judge, if you look at the 3 conditions, 2 of which have now been waived, the evading, I conferred with the state. It was something I've actually filed a motion for continuance because when you look at the police report, it was an execution of a search warrant at a location not my client's. And he was outside of the house. When the police arrived, everyone ran. My client states that he heard bangs. He was fearing for his life. So he ran and hid. And they found him hiding behind a shed in the area. The report from the probation department shows he's been clean. So that was a stupid mistake, Judge. The state and I looked at it. The motion was to get the video, but we worked out this deal. He's been sitting in jail for 2 months. His mother's present, who supports him and loves him. Other than that, the other violation was something about proof of change of address. And I think when he was arrested, he gave his father's address or something, which is different. And then I think the last one was not completing community service or something like that. So he's been working on doing well. We're hoping that the three months in ISF will make sure that he understands he cannot afford any mistakes. And we're hoping that you grant him this opportunity to prove himself and keep him on probation.
All right. And state, with regards to this evading, I haven't seen the police report.
Would you like the police? Pretty much the rendition is that it was a drug house that he was standing outside of, and with another gentleman. When the officers arrived at DPS, they did run off and did not stop when asked to stop, and that's the evader.
All right. Thank you. You may continue to confer.
Thank you.
Why is it takes people to get arrested to decide they're going to change their life and they want to do things differently? He should not have even been outside a known drug house. And I don't want to hear, I didn't know it was a known drug house, because if you live in a neighborhood, no matter where you stay, you know what house is the house that you shouldn't be at.
I think the gentleman he was speaking to was his uncle, which doesn't excuse where he was, Judge, but that's the situation we have.
And doesn't excuse giving fake addresses, doesn't excuse any of this. How old are you?
25.
You want to raise your right hand for me? You solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Kevin Jones.
Do you know what your conditions of probation are?
Yes, ma'am.
Do you know part of your conditions of probation, you can't hang around people who've been in prison, who are out of prison, who are on probation? Do you realize that?
Yes, ma'am.
So, is your uncle out of prison, been on probation, any of those things?
The defendant stood before the court claiming he had no idea the location he was found at was a known drug house and that he didn't realize he wasn't supposed to be. Around his uncle, both of those conditions had already been clearly outlined in his release terms, given his prior involvement with the justice system. And the fact that he's not a first-time offender, the explanation raised concerns. It's difficult to accept that someone with experience in the system could misunderstand such direct instructions. This situation isn't just about a single violation. It also highlights the attitude brought into the courtroom. Repeated non-compliance, paired with a lack of accountability, signals more than just a misunderstanding. It reflects a mindset that challenges the rules themselves. Whether the court considers this another chance-worthy mistake or a sign that more serious consequences are necessary remains to be seen.
You can't hang around any family member who's been in and out, well, who's been to prison, out of prison, on probation. It's not allowed while you're on probation. Do you want to go to prison? Then why are you behaving like you want to go to prison? Why? Why? You're 25. When are you going to grow up? And stop asking your mom to come down and cry and do this for you. Your mom should be enjoying the best days of her life, not dealing with someone who's 25 years old. You're a grown man and you're behaving like a child. When's the last time you had employment?
Before this happened.
Doing what?
Working at a moving company.
And how far did you go in school?
I graduated.
And what are you planning on doing with the rest of your life, other than hanging out with people you shouldn't be hanging around?
Need to stay out of trouble.
Well, everybody, I'm staying out of trouble. Are you staying out of trouble?
I try, Judge. I don't.
Everybody's staying out of trouble, unless it's good trouble.
Yes,
You're staying in bad trouble, and then you come to the court and you want to beg me to give you another chance. And you bring your mom down here when she has to pay for parking. I don't know if she drove or if she took the bus, but she could have been doing something else with her day.
Yes,
Instead, she's dealing with a grown man who don't want to behave well. Probation, is this what you all are asking for? Yes. All right, I'll deny the motion. Alternate amend conditions. And upon release, I want him on GPS. And it's going to be partial, and it's for employment only. So what that means is you're going to be on GPS. The only thing you're allowed to do on GPS is go to work and go back home. Who are you going to be living with?
Mother.
Does your mom want you living with her?
Yes.
Did you ask her? That's either yes or no.
Yes.
If I call her up here, is she gonna say you asked her, can I live with you?
Yes.
All right, so I see you looking up to see. Is he allowed to stay with you?
He does, but he's gonna abide by what I say.
All right, if you can come forward, please. Move over there. All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name for the record.
Anya Bledsoe?
All right. Is this your son?
Yes, ma'am.
All right, he's saying that he has your permission to live at your home. Is he allowed to live at your home?
Yes, he is.
All right. So he's going to be on GPS. He will only be allowed to go to work, then he has to come home.
Yes, ma'am.
If he violates those conditions, a motion to revoke is going to be filed.
Yes, ma'am.
Is there anything else you think your son needs to be successful?
If I tell you,
No, tell me.
you need to listen.
This case raises a difficult question. How many chances should a person be given before real consequences are enforced? The defendant is already facing serious drug charges, and just months after his initial court appearance, he's found at a known drug, house violating both the terms of his release and restrictions on who he could be around. At this point, it no longer appears to be a misunderstanding, it reflects a clear pattern of non-compliance. When the justice system continues to extend leniency in cases like this, it can send a broader message that the rules aren't being taken seriously. Of course, not every case requires prison time to create change, but for some, accountability doesn't register until it's reinforced in a meaningful way. Many would argue that a short term of incarceration could have served as a necessary wake-up call here. Instead, the defendant is returning to a home environment that may not challenge the behavior that brought him back to court in the first place. Was the judge's decision fair under the circumstances? Or did the system let another repeat offender walk away without meaningful consequences? That's a question worth asking.
I say, your people are the wrong, your choices of the people are the wrong thing in your mind. You can't get over, he was raised the correct way. So what he has done, it doesn't make any sense. Following somebody is no good. Be a leader. Mm-hmm. That's what I try to teach him. he's a good kid. He really and truly is. It's just like I say, following the wrong, even family. Because I have to cut mine out too. You know, so he will work. He helps me out with everything. He's a good kid, very mannerable and everything. And not to bring up when he was with you first time, I told him, you went up there and you let that lady tell you when you shouldn't have even acted like she wasn't talking to you. And I told him, you are to apologize to her. You know, that's the proper thing. That is the proper thing, because he wasn't raised like that. You know, I love him to death, but I will. And he has left home before. I told him, you think you're gonna run around here and do what you wanna do, get your things and go. I'm not gonna deal with that.
Okay.
So, you know, I spoke with him this time. Yes, he did, you know, my mama do the right thing. Okay, because I will call the police. I will turn him in. I don't have a problem with that because I don't need the headache.
All right, so let me just tell you, I'm gonna make sure you give your address to probation, because when he's released from custody, that's where he's going to be staying.
Ma'am.
And she will give you the phone number of who his probation officer is going to be.
Yes, ma'am. And I do believe, as far as that address thing, on his ID is 522.
Oh, no. Here's the thing. I'm going to continue him. We're starting from ground zero right now.
Okay.
So he's going to know where he needs to stay, and that's where we'll be, okay? All right, thank you.
Thank you. And Judge, regarding the GPS, can
All
we
right.
waive the fees?
Oh, just 1 second. Come back up, Mr. Jones. All right. Oh, don't be bowing your head like you have some kind of shame. Your mother is saving your life. You understand?
Yes, ma'am.
All right, the court is going to deny the motion, alter and amend conditions to include MRT, ISF upon release, and he's to remain in custody until transferred to ISF cognitive. There's going to be GPS partial for employment only, waive GPS fees, and it's going to be proof of employment within 30 days of release. And you are to reside with your mother until further notice.
That's state ISF, right, Judge?
Yes.
Thank you. Judge.
Probation, is there anything else he needs? All right, we can go off the record. Here's the thing. You may think you're an adult, but guess what? You're going to be living in your mom's home. So if she has her rules, if she wants the television off at 10, television goes off at 10. If you want to make your own rules, you need to get your own place. And I'm telling you right now, you are not allowed to leave your mother's house or go live somewhere else without the court's permission. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
Anything else you need from the court to be successful?
While not every person needs a prison sentence to change course, sometimes a firm consequence is the only thing that makes someone take accountability seriously. Allowing repeated violations without significant response doesn't just delay, can enable the cycle to continue in the end. The defendant was once again released, returning to the same environment that hasn't helped him grow. Whether this was a final opportunity to turn things around or another missed chance is up for debate. Thanks for watching. For more real case coverage and courtroom analysis, don't forget to like and subscribe. More updates coming soon.